Good day to everyone. Before we discuss crimes in general and their classifications, allow me to give you a quick review of the definition of law. Law is defined as a rule of conduct, just and obligatory, laid down by legitimate authority for the common observance and benefit. You must have heard this definition time and time again, but it is my belief that we reorient ourselves of what law really is in order for us to better appreciate criminal law. Law is a rule of conduct. Why? Because law serves as a person's guide in his relation to his fellow men and to his community. A law must also be just. Why? Because a law should be based on what is right and what is fair. A law must be obligatory. Why? Because since they must be enforced, then if they are merely directory, or if the people are given the option not to follow the same, then its purpose will not be served. Law must also be prescribed by legitimate authority, because in our system of government, the authority to make laws is vested in Congress, the Senate, and the House of Representatives, whose members are elected by the people. Now, if laws are not prescribed by legitimate authority, then the people cannot be expected to follow them. And last but not the least, law must be ordained for the common benefit. The welfare of the people is the supreme law. It must be applied equally to all, regardless of religion, race, political belief, gender, or status in life. Laws govern the conduct of people from cradle to the grave, or others say from womb to tomb. And the involvement of law in a person's life starts even before birth and even after death. Laws are a complex set of rules which are made to control the activities of individuals in a given society. Different laws are available for different situations, like laws that govern the relationship between the citizens and the state, otherwise called public laws. Examples of public laws are political and constitutional law, administrative law. We have also election law, taxation law, and of course criminal law. And we also have laws that govern the rights and liabilities of individuals towards each other, otherwise called private laws. Examples are the New Civil Code, the Family Code of the Philippines, and the Labor Code, to name a few. What then is criminal law? In a layman's sense, criminal law is connected with the act of forbidding particular forms of conduct and imposing punishment on those who engage in such acts and/or omissions. It defines criminal offenses and prescribes a specific punishment for them. In a legal sense, criminal law has three essential elements. First element, it defines crimes. Second element, it treats of their nature. And third element, which is the most important element, is that it provides for their punishment, either in the form of imprisonment or fine, or both imprisonment and fine. Take note that a law cannot be considered a penal law or a criminal law if it does not provide for a penalty for prohibited acts and omissions. Likewise, we must take note that criminal law is public law, or a branch of public law, because It treats of acts or omissions of an individual person as wrongs against the state more than against the offended party. This is the reason why criminal cases are filed in the name of the people of the Philippines and not in the name of the private offended party, who is merely considered as a complaining witness in that criminal case. For example, X physically injures Y. Y files a case against X before the prosecutor's office. The prosecutor finds probable cause, which leads to the filing of an information before the court. Now, the caption in that information filed by the prosecutor is captioned in the name of the people of the Philippines, not in the name of Y, who is the private offended party in that criminal case. The next logical thing to ask is, what is a crime? Ano ba itong crime? A crime is an act or an omission in violation of a penal law forbidding or commanding it. When you say act, it is a bodily movement producing some effect in the external world. Example of an act in violation of a penal law: sexual intercourse with a girl below 12 years of age is an act that constitutes statutory rape under Article 266-A, Paragraph 1D of the Revised Penal Code as amended. The act of sexual intercourse is a bodily movement which produces an effect in the external world. It produces an effect on the person of the victim against whom the act is committed. And such act will now constitute a violation of a penal law, and that violation with respect to the act of sexual intercourse constitutes the crime of statutory rape. On the other hand, an omission is a failure to act or perform a duty which, if not performed, is punishable by law. This is an example of an omission in violation of a penal law. A police officer who delays the release of a prisoner after being ordered by the court to do so commits the crime of delaying release under Article 126 of the Revised Penal Code. The omission here is the police officer's failure to perform a duty prescribed by law. How are crimes classified? Crimes are classified first as to the law punishing them. They can be felonies, offenses, or infractions or misdemeanors. Second, crimes can be classified according to their nature. They can be malum in se or malum prohibitum, or in the plural sense, mala in se or mala prohibita. Or third, crimes are classified according to their means of commission. They can be committed by means of dolo or by means of culpa. Fourth, crimes are classified as to their stages of execution. They can be consummated, frustrated, or attempted. And fifth, crimes are classified as to their gravity. They can be grave felonies, less grave felonies, and light felonies. And sixth, crimes can be classified as to their count. They can be compound crimes, complex crimes proper, composite crimes or special complex crimes, continued crimes, and continuing or transitory crimes. Let us now discuss each of these classifications in greater detail. Let's start with the classification of crimes as to the law punishing them. When you say felonies, they refer to crimes punished under the Revised Penal Code. When you say offenses, they refer to crimes punished under Special Penal Laws. And when you say infractions or misdemeanors, they refer to violations of municipal, city, or provincial ordinances. By the way, never make the mistake of calling a crime punished under a special law as a felony, because the term felony is exclusive for crimes punished under the Revised Penal Code. Crimes are also classified as to their nature. A crime, therefore, can be malum in se or mala in se in the plural sense. They refer to crimes which are considered inherently evil or wrong in themselves or wrongful by their nature, like murder. Murder is wrong per se, it's evil per se. Theft, taking the property of another without the owner's consent. And adultery, a woman, a married woman, who commits an act of sexual intercourse with a man who is not her husband. A crime can also be considered or classified as malum prohibitum, or in the plural sense, mala prohibita. They refer to crimes which are not considered wrongful by their nature, but are considered wrong because there is a law that forbids them. Like, for example, the cutting of a coconut tree without first securing a permit from the Philippine Coconut Authority. This is a crime that is considered malum prohibitum because the mere cutting of the said tree without such permit will already constitute a violation under Republic Act 8048 as amended by Republic Act 10593. Question: with respect to crimes punished under the Revised Penal Code and Special Penal Laws, which of these crimes are considered mala in se and or mala prohibita? Answer: generally, crimes mala in se are the felonies defined and penalized in the Revised Penal Code. However, when the acts complained of are inherently evil or wrong per se, they are deemed mala in se even if they are punished by a special law. So, the rule is, with respect to felonies in the Revised Penal Code and offenses in Special Penal Laws which are wrong per se or inherently evil, they should be classified or considered as mala in se, regardless of whether the crime is punished under the Revised Penal Code or punished under a special law. For as long as the crime committed is inherently wrong or wrong per se, then it should be considered, or they should be considered, mala in se. And with respect to other offenses punished in Special Penal Laws which are wrong merely because there is a law that forbids them, like for example, illegal possession of firearms under Republic Act 10591 or illegal cutting of coconut trees under Republic Act 8048 as amended, or the illegal possession of a bladed weapon as punished under BP bilang 6, these offenses which are not wrongful by their nature are merely considered mala prohibita. Question: what is the test to determine if the violation of a special law is malum prohibitum or malum in se? Answer: when given a problem, take note first if the crime is a violation of the Revised Penal Code or a violation of a special law. Because if it is a violation of the Revised Penal Code, then automatically it should be considered as malum in se. But when the crime is punished under a special law, that is the time you have to take a closer look at that particular crime, whether that crime is wrongful by its nature or merely wrong because the law forbids its commission. Also, you must analyze the violation. Is it wrong merely because there is a law prohibiting it or punishing it as such? If it is, then it is malum prohibitum. Now, if you remove the law, this is another test. Will the act still be wrong? If it is, then it is malum in se. Regardless of whether there is a law that punishes it, if the doing of the act is inherently evil, then that act should be considered malum in se or wrongful by its nature or inherently evil. Another question: why is it important to distinguish between crimes mala in se and mala prohibita? Answer: the importance of knowing the distinction between malum in se and malum prohibitum is the element of intent. Take note. Crimes mala in se, except for culpable felonies, require the attendance of criminal intent. To be considered malum in se, the commission of the unlawful act must be coupled with criminal intent. For example, to be considered homicide or murder, the offender must have acted with intent to kill. On the other hand, criminal intent is not an element in crimes mala prohibita. Because in crimes mala prohibita, the only question to be asked is, has the law been violated? The intent of the offender here is immaterial. The mere commission of the prohibited act is enough to constitute the crime. For example, X cut a coconut tree without first having secured a permit from the Philippine Coconut Authority. Here, X is liable for violation of RA 8048, an offense which is malum prohibitum. Let's now go to another classification. Classification of crimes according to their means of commission. Take note, however, that this classification applies only to felonies punished under the Revised Penal Code. It doesn't apply to offenses punished under special laws. Felonies, therefore, are committed either by means of dolo or deceit or by means of culpa or fault. Now, when you say a felony is committed by means of dolo, the act here, the criminal act performed by the offender, is performed with deliberate intent. For example, X, who harbored a grudge against Y, stabbed the latter several times while waiting for a ride home. Here, there was deliberate intent on the part of X to kill Y. And when you say a felony is committed by means of culpa or fault, this means that the wrongful act resulted from imprudence, negligence, lack of foresight, or lack of skill. For example, X, while cleaning his caliber .38 revolver, accidentally pulled the trigger, causing the same to fire and kill Y, who was just standing nearby. Here, the negligence of X in not first seeing to it if the gun was loaded resulted in the death of Y. Let's delve further. Let us delve further by making a comparison of the elements of both dolo and culpa. For both dolo and culpa, the offender must act with freedom of action and intelligence. When you say freedom of action, it refers to an act or omission done with deliberation and with the power to choose between two things. Because when a person acts without freedom, the law looks upon him as a mere tool. Thus, if X was forced at gunpoint by Y to stab Z, that is, if X will not stab Z, Y would shoot him, X here is not acting with freedom of action. When you say intelligence, it refers to the ability to determine the morality of human acts as well as the capacity to distinguish between illicit and an illicit act. Hence, if X was insane at the time he stabbed Z, X here cannot be said to have acted with intelligence because an insane person has no capacity to distinguish right from wrong. Now, if the offender acted with both freedom of action and intelligence, then he is deemed to have committed the crime with voluntariness. That is, he knows what he is doing and he is not forced to act against his will. So, in short, whether it is dolo or culpa, both these elements must exist, meaning the offender must act with both freedom of action and intelligence. In dolo, however, the offender must have acted with intent. In culpa, the wrongful act is caused by the negligence, imprudence, lack of foresight, or lack of skill of the offender. It is this third element that differentiates dolo from culpa. The elements, therefore, of intentional felonies are freedom of action, intelligence, and intent, whereas the elements of culpable felonies are freedom of action, intelligence, and negligence or imprudence. Question: what is intent? Answer: since intent is a state of mind, it can only be ascertained from the overt acts of the offender. The only way to know what is in the mind of the offender is to look at his external or bodily manifestations. Intent, therefore, is the use of a particular means to bring about a desired result. Example number 1. X, using his pistol, aimed and fired several shots at Y. Here, the overt physical act of X in aiming and firing at Y clearly showed his intention to kill the latter. Example number 2. X boxed Y, causing a black eye. Here, the intent of X is not to kill Y but only to hurt or injure him. Example number 3. X shouted at Y, "I will kill you," and thereafter slapped Y several times in front of many people. Here, the intent of X is only to either humiliate Y or injure him. Even if X shouted, "I will kill you," there is no intent to kill because shouting and slapping at someone cannot logically cause the death of the person. Question: how do we distinguish intent from discernment? Answer: intent is the determination to do a certain thing, an aim or purpose of the mind. On the other hand, discernment is the mental capacity to tell right from wrong. It relates to the moral significance that a person ascribes to his act. It is therefore synonymous with or akin to the element of intelligence. Another question: what about intent and motive? Intent is demonstrated by the use of a particular means to bring about a desired result. It is not a reason for committing a crime. On the other hand, motive is the moving power which impels one to do an act. It is therefore the reason for committing a crime. When there is motive in the commission of a crime, it always comes before the intent. But a crime may be committed without motive. Intent is an element of dolo, but motive is not. Another question: when is motive therefore important in proving the commission of a crime? Considering that motive is not an element of a felony, ano ba ang importansya ng motibo, para makatulong siya sa pag-prove ng krimen? The answer is found in the case of People versus Ramirez. And in this case, the Supreme Court said that motive becomes relevant when the accused has not been positively identified. Proof of motive becomes essential when evidence of the commission of the crime is purely circumstantial or is inconclusive. For example, as found in the case of People versus Bacares, a June 23, 2020 decision of the Supreme Court. The Supreme Court said in that case, it was the accused who had the motive to kill the victim due to some previous quarrels and disagreements between the accused and the victim. In fact, a few days before the fateful incident, the accused threatened to kill the victim after the latter accused the former of stealing her chicken. On that occasion, the victim threatened to have the accused incarcerated or imprisoned should he fail to pay her 25,000 pesos. So, these facts, as proven by the prosecution in that case, was interpreted by the Supreme Court as the motive of why the accused killed the victim. Question: what is negligence or lack of foresight? Negligence is the failure to use ordinary care. It occurs when the offender does not exercise the amount of care that a reasonably careful person would use under the circumstances, or the offender does something that a reasonably careful person would not do under the circumstances. It usually involves lack of foresight, or deficiency of perception, or failure to pay proper attention and to use diligence to avoid a foreseeable damage or injury. For example, X, a policeman, indiscriminately fires his gun in the air during New Year's Eve, which caused injury to another. Had X foreseen that firing his gun in the air could injure someone, the incident would not have happened. Question: what about imprudence or lack of skill? Answer: imprudence or lack of skill is deficiency of action in avoiding an injury due to lack of skill. It implies a failure in precaution or a failure to take the necessary precaution once the danger or peril becomes foreseen. For example, X was following Y's vehicle on the highway. As X was in a hurry to get to his destination, he attempted to overtake Y's vehicle by traversing on the opposite lane, which happens to be traversed by Z, who was then driving his motorcycle proceeding towards the opposite direction. As a result, X hit Z's motorcycle. Here, X failed to take the necessary precaution in seeing to it that the opposite lane is free of oncoming motor vehicles before attempting to overtake Y's vehicle. This is a clear and classic example of a reckless imprudence case, which could either result in damage to property or physical injuries or homicide. Let's now discuss crimes classified as to their stages of execution. Generally, they apply only to intentional felonies. It does not apply, or they do not apply, to culpable felonies and felonies by omission. They also do not apply to offenses under Special Penal Laws unless the Special Penal Law itself expressly provides for the attempted and frustrated stages of the offense. Intentional felonies can be consummated felonies. When do we say that a felony is already consummated? A felony is deemed consummated when all the elements necessary for its execution and accomplishment are present. Here, the offender does not have to do anything more to accomplish the crime. In other words, the crime here has been produced. For example, X wanted to kill Y. X then got a knife and stabbed Y in the chest, resulting in the latter's death. Question: are there felonies which do not have stages of execution, meaning they are always committed in the consummated stage? What do you think is the answer here? The answer is yes. They are called formal crimes. Formal crimes have no attempted or frustrated stage. The felony cannot be executed without performing all the acts of execution necessary for its commission. Examples: physical injuries, whether slight, less serious, or serious. You can also include here mutilation. They are punished as to the result, meaning the gravity of the injury, whether slight, less serious, or serious, cannot be determined unless they are consummated. Another is the crimes of slander, oral defamation, and libel. Here, the crime is consummated the moment the defamatory words are uttered and heard by a third person. Third person meaning a person other than the person to whom the defamatory words pertain. Included in the classification of formal crimes are felonies resulting from imprudence and negligence. Because what is punished here is not the act itself, but the mental attitude of the offender. An example of a felony resulting from imprudence and/or negligence is the felony of reckless imprudence resulting in homicide, or reckless imprudence resulting in serious physical injuries, or reckless imprudence resulting in damage to property. Another stage of execution is called the frustrated stage. A felony is deemed committed in the frustrated stage when the offender performs all the acts of execution which would produce the felony as a consequence, but which nevertheless does not produce it by reason of causes independent of the will of the offender. The reason why the felony is not produced must be due to a cause, or must be due to causes not attributable to the offender. Example: X stabbed Y multiple times in the chest and abdomen, but because of timely medical assistance, Y survived. Here, X has performed everything that needs to be done to end the life of Y. Y, however, did not die, not because X helped him, but because of the medical intervention rendered to Y that saved his life. Another example: X shot Y, seriously injuring him. X, however, was struck by his conscience and brought Y to the hospital, saving the life of Y in the process. Here, X's liability is for serious physical injuries only because of the absence of intent to kill. The reason why the intended crime was not produced was due to X himself, who saved the life of Y by bringing him to the hospital. Question: Are there felonies which do not have a frustrated stage? The answer is yes. Some of these felonies are rape. In rape, as I have discussed in my previous video, no matter how slight the penetration is, the felony is deemed consummated. If the male organ failed to touch either labia of the pudendum of the woman by some cause or causes other than the offender's spontaneous desistance, the rape is merely attempted. If the offender spontaneously desisted, then he will not be liable for attempted rape, but for some other crime like acts of lasciviousness. Another example of a felony which does not have a frustrated stage is the felony of arson. Why? The moment burning occurs, even if a small portion only is burned, the offense is deemed consummated already. If overt acts have been commenced, such as drenching the property with gasoline and lighting a match, but before it can be thrown, the offender was stopped, preventing the fire from touching the property, then the felony is only, or is deemed to have been committed only in the attempted stage, meaning attempted arson. Another felony which does not have a frustrated stage is the felony of adultery. Here, since the essence of this felony is sexual intercourse by a married woman with a man who is not her husband, the same principle applies as in rape. Another felony which does not have a frustrated stage is the felony of theft and also the felony of robbery. They are essentially the same, because in the crimes of both theft and robbery, the taking is deemed complete from the moment the offender gains possession of the thing, even if only momentarily. So, for example, the thief was already able to take hold of the cell phone out of the possession of the owner of that cell phone, even if he has not completely disposed of the property, but since the offender, the thief in that example, has already taken the property physically from the possession of the victim, even if only momentarily, even if only temporarily or momentarily, that taking is already deemed complete. And if the taking is already deemed complete, then the crime or the felony should already be deemed to have been committed in the consummated stage. That is the reason why there is no frustrated stage of the felony when we talk about theft and or robbery. Now, if the offender was prevented from taking the property because of extraneous matters like the arrival of neighbors or because of the shouts for help by the owner of the house, then the felony is only deemed to have been committed in the attempted stage. After discussing the consummated and frustrated stages of a felony, our discussion of the stages of execution will not be complete without a discussion on the attempted stage of the felony. Now, when we say attempted, it happens when the offender commences the commission of a felony directly by overt acts and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. Take note that when the felony is still in the attempted stage, there is something yet to be done, or there is something yet that the offender still has to do in order to produce the felony. Now, dissecting this provision in the Revised Penal Code, let us first focus on the phrase commences the commission of a felony directly by overt acts. What does this phrase mean? When we say overt acts, they are external acts which, if continued, will generally produce the intended felony. It is a physical deed or a physical activity indicating the intention to commit a particular crime, more than a mere planning or preparation, which if carried out to its complete termination following its natural course without being frustrated by external obstacles nor by the voluntary desistance of the offender, will logically and necessarily ripen into a concrete offense, as stated or ruled in the case of Rait versus People. Here are examples of overt acts. First example, X shot Y but missed. This is clearly an overt act which, had Y been mortally hit, will logically result into the felony of homicide or murder or even parricide, as the case may be. Another example of an overt act is this. While X lay on top of Y and kissed her, X removed her shorts and panty and tried to open her legs apart against her will. This is clearly an overt act that commences the commission of rape. Another example, X bought a deadly poison and mixed it with his wife's coffee. His wife was about to sip some of the coffee when the cup slipped in her hands and fell. This is an overt act which, had the wife drank the coffee, would logically result in the crime of parricide. Question: ano ba itong preparatory acts? Are they the same as overt acts? The answer is preparatory acts are equivocal acts which still require another act so that a felony will result. They are actually acts susceptible of double meaning or double interpretation. That is, in favor as well as against the offender, and which show an innocent as well as a punishable act. It is in this sense that they are not the same as overt acts. A preparatory act is committed prior to an overt act, and unlike overt acts, preparatory acts are not punishable unless they are in themselves punished as independent crimes. Here are examples of preparatory acts. X buying poison. The act of buying poison is a mere preparatory act because it cannot yet be ascertained against whom it is going to be used. In fact, X may just decide to use it against rats inside his house. Another example of a preparatory act. X carried a loaded gun and headed towards or proceeded towards Y's house. This is a mere preparatory act because the action of X in carrying a loaded gun and going to Y's house is capable of double interpretation. He may just be going to Y's house to have it cleaned, to have the gun cleaned, or he may use the gun to kill Y. However, even if this is a preparatory act, X here may be held liable for the independent crime of illegal possession of firearms if what he carried was an unlicensed gun. Another example of a preparatory act. X proposing to Y that he kill Z. The mere proposal to commit murder or any other crime for that matter is not punishable unless the act of proposal relates to the felonies of treason, rebellion or insurrection, or coup d'etat, such that the proposal to commit the same constitutes an independent crime. The same goes for the mere conspiracy to commit a crime. It is not punishable unless the conspiracy relates to the felonies of treason, rebellion or insurrection, or coup d'etat. By the way, with respect to proposal to commit a felony and conspiracy to commit a felony, I will be discussing these concepts in a separate video. Just wait for it. Note, in order for the overt act to be considered as an attempt of a felony, it must be directly related to the intended felony. If it is not directly related, then it is not punishable unless by itself, meaning the overt act, constitutes another felony. For example, X entered the house of Y by passing through the window. Is X liable for attempted robbery? The answer is no. X's act of entering the house of Y should not automatically be linked with robbery, for X's purpose may be to commit another crime like murder. X, however, may be held liable for the crime of trespass to dwelling because the entrance is definitely against Y's will. What about the phrase, does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance? What does that phrase mean? Here, the accused is not able to continue performing the acts to produce the felony. He is prevented by external forces and not because he himself has chosen not to continue. Examples are when the offender's weapon was snatched, for example, or the victim managed to escape, or the offender was overpowered or arrested. These are examples of external acts that could effectively prevent the offender from performing all the acts of execution. Now, if the offender voluntarily desisted, meaning he himself decided not to continue with his criminal purpose, then he is not liable. Take note. This is an absolutory cause by way of reward to an offender who, having commenced the commission of a felonious act, heeds the call of his conscience and returns to the path of righteousness. The reason for the desistance, however, is immaterial. Take note. Here are some examples of desistance. X wanted to kill his wife Y and thought of poisoning her. He then mixed a large amount of poison with the coffee which he gave to his wife. When Y was about to sip from the cup of coffee, X got struck by his conscience and took away the cup from Y's hand. Here, X was not able to perform all the acts of execution necessary to commit the crime of parricide because of his own spontaneous desistance. Question: is he liable for attempted parricide? The answer is no. Although X here had commenced the commission of a felonious act, he will not be held liable for attempted parricide because his desistance is considered as an absolutory cause, which will absolve him from criminal liability. Same example. What if X desisted not because he was struck by his conscience, but because he decided not to kill Y that day? Will X now be held criminally liable? The answer is no. The reason for this spontaneous desistance is immaterial. Another example. X and Y got into a heated verbal altercation. X then cocked his caliber .45 pistol and aimed it at Y, ready to pull the trigger. Y begged for mercy. X took mercy and left. Question: is X liable for attempted homicide? The answer is no. X's desistance is an absolutory cause that will not make him liable for attempted homicide. But his act of pointing a gun at Y in the heat of anger will make him liable instead for the crime of other light threats under Article 285 of the Revised Penal Code. Here are more examples. X pointed a gun and fired at Y but missed. X was about to fire at Y for the second time, but X changed his mind and left. Question: is X liable for attempted homicide? The answer is yes. For X's first act of pointing a gun and firing at Y, he is already liable for the attempted felony. He had already commenced the commission of a felony by his act of firing at Y, but did not perform all the acts of execution which should produce the felony for the reason that he missed his target and not because he desisted. Take note here that the desistance came only after X's first act of pointing a gun and firing at Y. Another example. X stole Y's cell phone but returned it to Y minutes after taking the same. Question: Is X liable for theft? The answer is yes. X is liable not just for theft in the attempted stage, but for theft in the consummated stage. His desistance by returning the property to Y came only after the felony had been consummated. Desistance does not have any legal effect in the frustrated and consummated stage of a felony. Take note that if the felony is still in the attempted stage, the offender still has control over his felonious act. That is, he may or he may not perform all the acts necessary to consummate the felony. In such a case, the offender here is said to be in the subjective phase of the felony. Now, if the felony is already in the frustrated or consummated stage, the offender has performed all the acts necessary to produce the felony. It is frustrated if the intended felony is not produced, and it is consummated if the intended felony is produced. In such a case, the offender is said to have reached the objective phase of the felony. It is at this phase where the offender no longer has control over his felonious act. To summarize, allow me to list down the fundamental distinctions between attempted and frustrated felonies. In attempted felonies, the offender has not performed all the acts of execution, whereas in frustrated felonies, the offender has performed all the acts of execution. In attempted felonies, the felony is not produced by reason of a cause or accident other than the offender's spontaneous desistance, whereas in frustrated felonies, the felony was not produced by reason of causes independent of the will of the offender. Now, in attempted felonies, the offender still has control over his felonious act. That's what I called in the previous slide as the subjective phase of the felony. Whereas in frustrated felonies, the offender no longer has control over his felonious act. The offender here is deemed to be already in the objective phase of the felony. In attempted felonies, take note that they do not include the frustrated stage of the felony, whereas in frustrated felonies, a frustrated felony necessarily includes the attempted stage of the felony. What about the fundamental distinctions between frustrated and consummated felonies? In a frustrated felony, the criminal purpose of the offender is not accomplished, whereas in a consummated felony, the criminal purpose was accomplished or is accomplished. In a frustrated felony, it does not include the consummated stage of the felony, whereas in a consummated felony, it necessarily includes the frustrated stage. Now, for both the frustrated and consummated stages, the offender no longer has control of his felonious act. Let's now go to classification of crimes as to their gravity. This is based on Articles 7, 9, and 25 of the Revised Penal Code. And take note, they apply to felonies only. the basis here is the penalty prescribed by the Revised Penal Code and not the actual penalty imposed by the court. If both imprisonment and fine are prescribed as penalties, it is the penalty of imprisonment which is used as basis, not the penalty of fine. Hence, felonies according to their gravity can be grave felonies, less grave felonies, and light felonies. When we say grave felonies, they are those whose prescribed penalty is either capital punishment, referring to death, the death penalty, or any of the afflictive penalties, prisión mayor, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, reclusión temporal, and reclusión perpetua. Here, for as long as the minimum, medium, or maximum period of the prescribed penalty is an afflictive penalty, then the felony is considered as a grave felony. Take note that the death penalty has been abolished already pursuant to RA 9346. For example, if the penalty prescribed for a felony, let's say, is prisión correccional medium to prisión mayor minimum, the felony here is considered a grave felony even if the minimum penalty imposed for this particular kind of felony is a correctional penalty. What about less grave felonies? They are those punished with penalties which in their maximum period are correctional. The correctional penalties under Article 25 are destierro, suspension, arresto mayor, and prisión correccional. Now, for as long as the maximum period of the prescribed penalty is a correctional penalty, even if the minimum period is a light felony, the same is still considered as a less grave felony. For example, if the penalty prescribed for a felony, let's say, is arresto minor maximum to arresto mayor medium, the felony here is considered a less grave felony. Why? Because the maximum period of the prescribed penalty is arresto mayor medium, which is a correctional penalty. What about light felonies? Light felonies are those penalized by arresto minor or a fine not exceeding 40,000 pesos or both. Question: what is the importance of classifying felonies according to their gravity? Answer: the classification is necessary in relation to prescription of crimes under Article 90 of the Revised Penal Code. Why? Because the prescription of crimes depends on the gravity of the felony. It is also necessary in relation to the complexing of crimes under Article 48. Why? Because only grave and less grave felonies can be complexed. It is also necessary in relation to the duration of the subsidiary penalty to be imposed under Article 39, subdivision number 2 of the Revised Penal Code. Why? Because it applies when the principal penalty is only a fine such that the period of subsidiary imprisonment is not to exceed 6 months if the offender shall have been prosecuted for a grave or less grave felony, and the period of subsidiary imprisonment shall not exceed 15 days if the offender shall have been prosecuted for a light felony only. It is also necessary in relation to the determination as to what stage of execution is punishable. In Article 7 of the Revised Penal Code, light felonies are punishable only when they have been consummated, except when committed against persons or property. And lastly, it is necessary in relation to the determination of whether or not Article 125 of the Revised Penal Code was violated. Here, a person who is detained pursuant to a warrantless arrest must be brought for inquest and charged in court within 12 hours for crimes punishable by light penalties, 18 hours for crimes punishable by correctional penalties, and 36 hours for crimes punishable by afflictive and capital penalties. Then we have classification of crimes as to count. They refer to the plurality of crimes. Crimes as to count can be compound crimes. They can also be complex crimes proper, composite or special complex crimes, continued crimes, and continuing or transitory crimes. Now, the discussion of these crimes are found in the videos I already posted in this channel. Please find the time to view or listen to them. Here is a fundamental guide to the distinctions between crimes punished under the Revised Penal Code and crimes punished under Special Penal Laws. For crimes punished under the Revised Penal Code, the moral trait of the offender is considered. Criminal liability arises only when there is dolo or culpa in the commission of the punishable act, whereas in crimes punished under Special Penal Laws, the moral trait of the offender is not considered. It is enough that the prohibited act was voluntarily done. In crimes punished under the Revised Penal Code, good faith or lack of criminal intent is a valid defense, unless the crime is the result of culpa. Whereas in crimes punished under Special Penal Laws, good faith is not a defense. Why? Because the mere commission of the prohibited act will already or is already enough to constitute a violation under that particular Special Penal Law. For crimes punished under the Revised Penal Code, the degree of accomplishment is taken into account. Hence, there are attempted, frustrated, and consummated stages in the commission of the felony, whereas in crimes punished under Special Penal Laws, the crime is committed only when it is consummated. There are no attempted or frustrated stages unless the special law expressly penalizes the mere attempt or frustration of the crime. For crimes punished under the Revised Penal Code, mitigating and aggravating circumstances are taken into account in imposing the penalty, since the moral trait of the offender is considered. Whereas for crimes punished under Special Penal Laws, mitigating and aggravating circumstances are not taken into account in the imposition of the penalty. Now, for crimes punished under the Revised Penal Code, when there is more than one offender, the degree of participation of each in the commission of the crime is taken into account in the imposition of the penalty. Thus, offenders are classified as principal, accomplice, and accessory, whereas for crimes punished under special penal laws, the degree of participation of the offenders is not considered. All who perpetrated the prohibited act are penalized to the same extent. There is no principal or accomplice or accessory to consider.